Ms. Marinos.
Bonjour, mesdames et messieurs du comité. Merci de m'avoir invité à contribuer au travail important que vous faites sur le projet de loi C16 et la protection des victimes. Je m'appelle Angela Marinos, je suis l'avocate générale en chef au Centre Raoul Wallenberg pour les droits de la personne fondé par l'honorable RWCHR. I joined the Wallenberg Center a couple of years ago after almost 23 years of litigating at the Department of Justice, where I represented the Attorney General of Canada and various federal ministers across a number of governments, across party lines, and across all levels of court. As such, I'm well familiar with defending federal decisions and policies and the law as it is. But today I'm here to advocate for the law as it should be. Je pense aussi et j'espère que mon expérience devant la Cour suprême du Canada, au nom du Centre Wallenberg, sur des questions que ce projet de loi aborde pourra éclairer votre examen. Our brief offers 5 main proposals, but in the time I have, I want to focus on 3. Independent legal representation, providing a holistic, trauma-informed approach to our understanding of exploitation in the trafficking context, and adding human trafficking and sexual services offenses to the protective screening mechanism at Section 276 of the Criminal Code. Before I elaborate on these issues, I want to commend the broad reform that's been proposed with Bill C-16, and at the same time, we believe this bill can be strengthened in a handful of areas. The biggest transformational change to this bill would be providing independent legal representation for victims and survivors of sexual violence and sex trafficking from the moment they engage with the legal system, when they go give their statement to the police, to appearing in court. Why are we asking for this? Because we've seen victims torn apart by the legal system time and again, because they don't trust the system as it is, as demonstrated by the fact that 94% of these crimes are not reported to the police, and because victims and survivors do not have a meaningful voice in the judicial system. The Crown is not their voice and cannot be their voice, and currently there are, as you know, very limited circumstances where complainants have independent legal standing. This is not enough. We can and must do better. We've done it before, and we can do it again. Given the time, I'm not going to touch on our other proposal where we seek an independent right to counsel where the Crown seeks to admit evidence of prior sexual activity, or where there is a joint application, but those submissions are detailed in our brief. I want to move very briefly to our second proposal with respect to exploitation and then touch on Section 276. We are urging a holistic, trauma-informed lens to be applied to the definition of exploitation and to make trauma and PTSD an integral part of the definition. We're also asking that the definition of exploitation include the belief that the safety of their residents or pet is threatened if they fail to provide the labor or service. And we are asking that the term manipulation be added to the factors that should be considered. Turning to Section 276, we submit it's important to specifically enumerate human trafficking, sexual services offenses, and other sexual offenses. Why? Because otherwise, defense counsel will argue and the courts will find, as they did at the Court of Appeal in R versus AM, that it was Parliament's intention to exclude them. Does Parliament really intend to exclude the benefit of Section 276 from these groups? I find that hard to reconcile with Parliament's stated intention to protect the dignity, privacy, and equality interests of these vulnerable groups. Now, I appreciate that the proposed amendment seeks to add the phrase, or any other offense under this act that is of a sexual nature or that is committed for a sexual purpose. However, as we submitted in the brief, and as one of the Supreme Court judges put it in the R versus AM appeal, that will be rife with litigation. That phrase will only bog us down in arguments that the offense was not committed for a sexual purpose. The solution then is to list the offenses. In closing, we know this government and this committee want to be transformative and are committed to providing those subjected to sexual violence and sex trafficking with better, stronger protections. We can do this, and I urge you to accept the changes. Thank you for your time and consideration.